welcome to your real estate journeys, expert tips for buyers and sellers. I'm Dolly Lopez, your realtor and real estate coach in the state of Florida and Kentucky. Today's Thursday, and I'm really glad to have Valerie on board. Like every Thursday, or at least we try to do this every Thursday, to give you information that you much need to educate yourself in your real estate transactions. Anyways, Valerie, welcome. How are you?
Good, Dolly. Super excited to be here with you and your followers.
I'm excited to have you. I love talking to you guys, to the team, because it really gives us a different perspective, and it educates us in things that we could do to prevent anything that we wanted to get to prevent in any given time. Anyways, so today we're going to talk about title. I have received a few calls in the past week or so about parents wanting to leave the house to their kids in title, want to add their minor children to the title. So what's your opinion on it, and what would you suggest?
Okay. So first and foremost, what I want everyone to know is that in Florida, you cannot hold title as a minor. And a minor is defined as someone under the age of 18. So if you're under the age of 18, you do not legally hold title. So that's something everyone has to keep in mind. Now, secondly, to answer that question, if you have a mortgage on the property, which a large percentage of people typically have mortgages on their property because not a lot of people can afford to pay out of pocket. So if you have a mortgage on your property, the best way to make sure that you can leave that house to someone, to a loved one, whoever it may be, then you need to do it through a will. Your only option is to do it through a will, because the day you sign that mortgage, the day you purchased that loan, you did so by signing a mortgage that has a term that says that you will not be changing title without the mortgage company's authority. And no mortgage company is going to agree for you to change title to add your loved one, because that loved one never qualified for the mortgage. That loved one was not there when you actually went through with the mortgage. So the only way you can assure that that property is passed on to whoever it is you want to have the day that you're not here is through a will. That's the only way you could do it.
So then what would happen if both parents died in a car accident, God forbid, but what happens to that property? Let's say that they have a couple of properties and they have 3 minor children.
So if we have a couple that passes away and they don't have a will in place as to who they want to leave their property to, then their beneficiaries, whether it be children or maybe it's their parents or maybe it's niece or nephews, whoever their beneficiaries will be, have to open up a case in probate. And that's through the court. A probate is a court case issued through the court system, and the judge will then decide, per how the law is structured, who will then get that property. So in Florida, the way that works is the first in line to obtain any kind of property from a loved one who has passed away would be the children of the people who pass. If there is no children for whatever reason, then it goes backwards to the parents. So for instance, if I were to pass away and I have no children, then it would go to my mother and father if my mother and father are alive. If my mother and father are not alive, then it can go to an aunt, to an uncle. It gets a little more complicated, the strategy, but the judge or the court system will then follow statute as to how that process is done.
What about siblings? Where would they fall into that category?
So if it's siblings and you have no parents, then it passes forward to your siblings in equal parts, right? So if I have 2 brothers, it'll go 50% to one brother and 50% to another brother.
Got it. Okay. So what would you say are the different type of ways someone can hold title in the state of Florida?
So in Florida, we have 4 popular deeds in Florida as to how you hold property. One of the most common ones is by the entireties. What does that mean? The entireties is a specific way to own ownership when you're married. It has to be with a spouse. Only a spouse can hold a property by the entireties. And what that means is that you own it as one. So for instance, my husband and I have a property. my husband and I own that property as one. So I own 100% of the property and he owns 100% of the property. That's a special I guess a special way to hold property as a married couple under Florida law. Florida law recognizes a marriage and gives that marriage certain rights. One of those is by the entireties, which is the way you hold property. Secondly, is with the right of survivorship, also a very common way to hold property when you're not married. So, with the right of survivorship means if something were to happen to me, let's say me and Dolly own a property and something were to happen to me, whether I have a will or not, it doesn't matter. My ownership of that property automatically passes on to Dolly, right? If something were to happen to Dolly, whether she have a will or not, and I remain alive, then that property will automatically pass to me. A lot of people do that in that way in order to prevent going to the probate or going to the court to request a change of title. Because that basically assures that even though I don't own the property with my spouse, I could still assure that even if I own the property with a friend, I will automatically get transfer of that property once that friend passes away, and
Okay.
vice versa. Then the third way to hold property, which is one of the more common ways too, is by tenancy in common. What does tenancy in common mean? Meaning, let's say me and Dolly own a property. I own 50% and Dolly owns 50%. I could do what I wish with my 50% and Dolly can do what she wishes with her 50%. When I say you could do whatever, meaning I can leave it in a will to whoever it is I wish. And Dolly can leave it in a will to whoever it is she wishes. If for whatever reason I pass away and I don't have a will, then it goes on to my beneficiaries. Same for Dolly. If Dolly were to pass away with no will, then it automatically will pass to her beneficiaries. And
Okay.
then the last way to hold, which is primarily done when we see that a mortgage is paid off, is called either a ladybird deed, which a lot of people recognize it by ladybird deed, or a life estate deed, both of which are the same. They're interchangeable, the name, but they're both mean the same thing. And that means that I will hold the property for my lifetime and I could do what it is I wish for my lifetime with the property, but I cannot waste it. What does it mean by waste? It means I cannot devalue the property by causing some kind of damage to the property. So I have to maintain the property for my lifetime. I could also sell it if I wish. And if I sell it, then it terminates the life estate. But what a life estate means is I will own it for my lifetime. The day that I pass away, it will automatically transfer to whoever I put as beneficiaries in that life estate deed. For instance, if I put my cousin, then the day that I pass away, my cousin will automatically get ownership of that property by simply filing my death certificate. She doesn't have to go through the court system, or he doesn't have to go through the court system in order to transfer ownership to that person.
Got it. So is this a way that you can also do for children?
100%. That's a very common way that people do it for children because we don't know what's going to happen in our lifetime, right? We don't know if we're going to want to sell a property. We don't know if we're going to want to rent the property. We don't know what we're going to want to do with the property, but we want to make sure that if we pass away or something crazy happens, that our children get it. So that's why we do life estate, because it's you still maintain your ownership and your rights as an owner, but it also protects your beneficiaries, your children, or whoever it is, loved ones that you want to pass your properties to, because they don't have to worry about going to probate. And that's an additional cost, an additional headache, really, that your loved ones will have to go through if they were not to be listed as beneficiaries in a life estate.
Got it. We just need to keep in mind that if your children are minors,
Yeah.
there's a different step that they would have to take
Right.
whenever.
The court will then issue a guardian that will hold that property for the benefit of the minor until the minor is of age.
Perfect. Valerie, thank you so much. I really appreciate you coming aboard and giving us all of this information. You watching at home, make sure you subscribe to our channel, share it. You help us a lot by subscribing so more people can see our content. If there's any questions, feel free to reach out to our office's number. You can reach me directly at the number on the screen, or you can reach Valerie or her team at the 305-459-8280. Thank you guys, and I'll see you next week. Bye
Bye,
bye.
everyone.